We were in the other building all morning.
Yes. So let's go live. We're live. Welcome, folks. This is House Corrections Institutions. It is Wednesday, February 11th. This is our 1 o'clock meeting. We're running a little late. We're going to have a general discussion right now in terms of our pretrial supervision program and really trying to find out what is working with it and what is not working with it. And then when we have our legal counsel available to us, she'll walk us through the new draft. It's a pretty complicated set of amendments to it. So Kim, welcome. If you can introduce yourself for the record.
Yes, my name is Kim McManus. I'm with the Department of State's Attorneys and Sheriffs as their legislative attorney. So I have a few possible ways we can start, Chair. I did watch testimony on Friday of the walkthrough and the conversation that took place, and it felt like there was some confusion in a few spots. And so my initial presentation today was to take a step back and run through
The program?
well, to run through really how we wind up getting here. 'Cause I know there was a number of questions about where the Department of Corrections referral would come in and at what stage, and could it come earlier, could it come later? So I can do that, or we can just jump right into where, and I did have a lot of comments about the proposed language.
We're not there for the language.
Okay.
So we need Hillary here. So if you could make this larger, so.
Yeah, see, I was having trouble this morning, but hopefully someone struggled up there. Okay, there we go. Do them.
To read it.
Yes. Sorry, one sec. Many things. Sure. So what I'm going to do, because one thing I was really thinking a lot about Friday when I was listening to testimony is the amount of information you all have to absorb and the breadth of information on different topics. It's fairly overwhelming. I am not an auditory learner. I have to see things to understand them. So I did make this very rudimentary flow chart, just so folks can have it in hand. We're not going to go bit by bit through it, but as we're talking, I think it'll be helpful just to take a look at it. So we just pass it around.
Thank you.
Yes. And I apologize. It's like a seventh grader did it.
Got it.
Good.
That'll work.
Yeah.
And it
I need it.
should be, that's it stands out.
It'd not be good once you-
Two tries. You're welcome. So the chair.
This by hand.
Yeah, that's why. That's
old.
yeah.
Old school.
Yes, embarrassingly showing my age.
That's pretty.
Starts right off.
I'm gonna leave. You're welcome.
Could we get a star off the wall?
She deserves it.
Thank you.
Finally knows the level that we function.
It's crayons.
Yeah, no, this is complicated, and for the most part, your committee deals with folks once they're detained. And you don't always get into the messy middle part, especially around arraignment, of all the options that are there. And one of the things that I was hearing on Friday was, and I think this is the big question of who's eligible for this program and who should be eligible, like who does this program best serve? And I won't get into details of the proposed language, but there's proposal to change the eligibility requirements. And I think one of the big questions is, are we looking for this program to serve high-risk defendants who would otherwise be detained, but for pretrial supervision, or lower risk, so to speak, they're not eligible for detention, but they're really struggling with getting to court, not committing more offenses, need that sort of wraparound programming that we've seen in our accountability docket, and that we've seen great success there with. And so those are two very different populations as far as what's coming out of arraignment and where and when you would have Department of Corrections involved. The way the proposed wording, there's a conflict there of who's eligible. And then I can wait until after your legislative council goes through it to just weigh in on thoughts on that. But the other big issue for us, and again, we'll wait till leg council, is the who's filing when a violation occurs. And we have very strong feelings about that, but I will wait till you have your walkthrough. As far as who's participating or not, actually, this was just mentioned, I believe this morning, at the accountability docket joint hearing. There theoretically seemed like a very nice overlap there with the 5 or more dockets being the eligibility requirement for the accountability docket and for the pretrial supervision program. What they found at the accountability docket is that the cases are moving so quickly that, and DOC is involved, but it's more so DOC being involved with explaining what's going to happen with the disposition of a case and where things would go, less being the liaison of the providers and services that I believe the pretrial supervision was seeking, the cases that take longer, the cases that are taking 3, 6 months, 9 months, that you need those continuous check-ins to be supervising someone, making sure they come to court, making sure they check in with any providers that have been suggested. That's happening so rapidly in the accountability docket that they're not needing pretrial supervision for those cases, or I believe it worked for one person, hit the piece. Big picture, the special prosecutor, Zach Waite, said, whatever changes happen here, definitely you do not need to wait till 5 dockets to be eligible for pretrial supervision. And I know that's one of the proposed changes to take out that language. So we were supportive of that. But right now, I think the big issue is really figuring out who we want this program to serve, who would it best serve. And right now, it's sort of trying to serve too many, but not having the resources to properly serve them. If you're going to be serving the high-risk defendants who would otherwise be detained, it needs to be a much more intensive supervision. And as CSG said, that's simply not what DOC has available. You can't do phone check-ins with someone who would otherwise be detained. And vice versa, on the other side, if it's the lower risk, but needing more social, mental, emotional, just executive functioning support, then that coordination piece, right, needs to just be better sewn up. So I think that's why we're not seeing folks in it. It's very long
It's not
to that.
meeting the needs of either version, either the high risk or the lower risk folks. And then the 5 dockets kind of indicate maybe they're high risk, or maybe they just keep cycling through. And
Yeah.
it's taken care of. So if the pretrial supervision, well, what I found interesting, what you just stated about the pilot project up in Chittenden County, the reason not many people, only one person was sent to pretrial supervision is that there's already, the coordination was really focused on our community providers with the courts and going through the criminal justice system. So if our community providers were there at the table while the person was going through an arraignment or kind of what's the next step, but then you've got the circle of support from your community providers, then you really don't need that pretrial supervision.
Well, as far as the coordination piece, right? And that was one of CSG's recommendations, that you need to better coordinate all those folks. If they're not in the room, then DOC being that hub to connect all those folks makes a lot of sense. But to your point, Chair, if they are in the room, then that's happening. We're doing direct
Automatically.
handoffs more easily. Now, again, if we're looking at cases that, are sort of not the accountability docket, but cases that take longer from start to finish. Where we could see the benefit is that DOC is providing that check-in of, are you seeing the
To the
provider that you're
providers.
connected with? Did you follow up? Are you having trouble getting there? Do you need a ride? Do we need to organize that? Like, that very sort of social worker,
Parenting.
just giving that executive functioning piece, sort of being that outside person to do that. And again, the capacity issue of whether DOC can do that is a question.
Why don't you go through this? This would help the folks.
Right, so when I was writing this, when listening, what I wanted to really get to is, again, as you all are thinking, who should pretrial supervision be for? Is it folks who would be in the community but need that extra wraparound, or detained people who could otherwise be detained pretrial? But this pretrial supervision is a least restrictive option to that. I wanted to just walk through how we would get to either being in the community pretrial or detained pretrial. So starting at the top, at the incident, criminal incident behavior, something occurs, you can either be cited into court, given a piece of paper, come in 4 weeks, March 5th, 9 a.m. to court, or you can be arrested. And there's all sorts of rules on what can happen when. We won't get bogged down there. At time of arrest, you can either be released with conditions to then go to your court date. So essentially cited to court, or you can be detained at that point.
That's all decided by your law enforcement.
Excuse me.
That's all decided by the arresting officer.
So the arresting officer makes the decision to arrest or to cite.
Right.
If they are arrested, then if they wish to detain them, they have to have a judicial order to detain. You're calling a judge or getting a judge's order involved.
The first decision as to when you get into the criminal justice system is when that law enforcement officer, either your local law enforcement officer or your state police, arrests the person or cite the person. That's the first decision.
Yes. So you're either coming to arraignment with your citation in hand, or you've been detained and you're being walked in to arraignment. At arraignment, the judge runs through what you're being charged with. The prosecutor is going to suggest what they think is appropriate as far as conditions of release or bail, or whether to be held without bail. Always important to remember that in Vermont, bail can only be set if you are a risk of flight. That is when bail can be set. Otherwise, conditions of release are to ensure or try to ensure safety while pending trial. So you can't set bail because it's a public safety issue. And that's important. Bless you. Bless you. I'm just going to jump ahead a sec.
So to this point, does that make sense to folks?
Yeah, the preface is super helpful.
So if someone in this room, first offense, it's say there's no victim involved, it's possible that you're released with personal recognizance, which just means we trust you to come back. We don't need to issue a court order of any kind. We'll see you in 20 days. If the prosecutor cannot convince the judge that the person is a flight risk, no bail will be set. But the prosecutor may say, we need a few conditions to ensure public safety, things like not contacting the victim, staying so many feet away. We might ask for a curfew. If we think that's appropriate, we might ask for what's called a responsible adult, that somebody comes forward and essentially says, like, I'm going to watch out and make sure that Representative Sweeney follows the conditions, and they sign a piece of paper, variety of conditions that can be set. The court always has to set the least restrictive of the conditions. So they have to take all the information at hand. They can't just set whatever they want. They're always having to kind of winnow down what is needed to keep the public safe. If there's a risk of flight, then the court can determine bail and set bail to mitigate that risk of flight, so that bail amount. Often with bail, I'm sure there's times where it doesn't happen, but almost always if you have bail set, you're also going to have some conditions of release as well, as far as what behavior you can or cannot do while waiting. In some cases, we can argue for a hold without bail. I know you've heard that term many times, I believe. So a hold without bail, there's two statutes that cover this, 13 VSA 7553 and 13 VSA 7553 little a. The first one is when charges that carry a maximum life sentence, we can request a hold without bail. The reasoning is that somebody who has a charge against them with a maximum life sentence, that there's inherently a risk of flight built into that the person's exposure for such a high consequence may make them more likely than not to want to flee and not come to court. 7553A, you need to have a felony that involves an act of violence against another person. And you need to argue, the state has to argue two things. First, it needs to show evidence of guilt is great, that there was an act of violence against a person. And then it has to show that there's a substantial threat of physical violence to any person. So you have to show a future threat in order to ask for a hold. So either case, if the court orders hold without bail, that person will be detained pre-trial. If bail has been set, but the person cannot make bail, they will be detained pre-trial. If they post bail, they're in the community with their conditions of release and they have their posted bail. When someone's been detained because of a hold without, I didn't get into this part because I didn't want to make it too messy. There are appeals involved. There are often motions to reconsider, to argue that bail can be set. So sometimes someone could be held initially and then bail could be set. If they make bail, then they could be out in the community. So these are not set in stone once you've gone into a certain bucket at the end.
So this is really helpful. And then the next step, could you just explain quickly what gets you, then it's pretrial supervision. And then what I want to do, because we're on a time crunch, but I think if you finish up with this, then we're going to switch to our legal counsel because she can only be here until 2:00.
Okay, perfect.
So I think if you finish this in terms of who gets the pretrial supervision piece, I think you laid it out really well in terms of who are we trying to address. The high-risk offender has a lot of needs, high risk to reoffend. The severity of the crime was kind of maybe moderate or high, we don't know. Or the person who's a low risk that just is kind of starting to cycle through the system or maybe first coming into the system. Those are policy decisions we'll have to make. But anything else, your next step for in the community pretrial?
So in the community pretrial, currently, to get into pretrial supervision, you would either need to violate a condition of release. So remembering that when the court orders the condition of release, this is a court order that you follow these conditions. Violating that is a separate crime. It's criminal contempt. And the prosecutor, upon hearing that someone has violated a condition of release and has evidence of that, can charge that as a separate offense. So that's one way currently that you would be eligible for pretrial supervision, that you've shown that you're struggling essentially on your conditions. The other eligibility possibility is that you have five pending dockets. And the important piece here is that currently is written, so you have either the violation of a conditional release or five pending dockets, and you pose a risk of non-appearance for future court hearings, or you're a flight risk, or you're endangering the public. So the court has to come to that analysis before putting somebody in. And again, the court still has to have this be a least restrictive option. And I believe there was a example given last Friday that somebody was offered a 24, the recommendation was going to be a 24-hour curfew, and the least restrictive option would be, or you could do pretrial supervision. That would make sense as an option. But again, from here, I really left this blank because that is the next question of which arrow do you want going into pretrial supervision, which box, and it could be both, but then that's really, again, realizing these are two different populations that need two different types of supervision pretrial, and whether DOC is given the proper resources to do that.
So currently, when a person's going through this, they're arraigned, they're sent out, either personal recognizance, conditions of release, bail is set, and they've posted bail. Or if they haven't posted bail, they're detained and then they post bail, and then they're released to the community. But right now, everywhere throughout the state, except for that accountability court in Chittenden County, there's no supervision of those folks in the community by DOC or anyone.
The only supervision, so to speak, is that if the person is seen violating a condition, like somebody calls that in, then law enforcement responds, but there's no proactive supervision right now.
That's important to keep in mind. Okay. And the reason that this program was established, it came from Senator Sears as a way to provide some public safety, to have a little bit of supervision for those folks cycling through the criminal justice, cycling through the courts. Any questions on this before we transition to Hillary to walk us through the draft? This was very helpful. I really appreciate you doing this.
Wonderful. And I would hopefully beg for about 10 minutes or so after, just to a few comments.
We're limited because Hillary has to be somewhere at 2:00, so I want to at least walk through the confusing draft. But this sets a good groundwork for people to understand. Matt, you've got a tight schedule too?
Can't hang around. I'm sorry, I got tons of other pressing things to deal with, so I should probably come back another time, honestly. Just can't do it.
Because we need to hear from defense counsel.
Because this is only a small change from what we walked through last week, I don't think that it will take as long as a walkthrough otherwise would. But
I just want to flip you to,
Do whatever you gotta do. See what happens. Just,
because we need to hear from the defense. We wanted to get all the players in the room together, because this is really important for us to understand all the moving pieces. I would rather have Matt up because I think it's going to be more confusing just knowing the committee. It's going to be a little more confusing to follow
interesting
the
when you
language.
change stuff. Because I looked at the bill, I had all kinds of questions, but.
You have questions about the changes?
Questions about the bills, what I saw, I mean, I don't know what it's gonna say, so if you're changing something.
Well, I'm at the point right now where members of the committee need to understand what the process is now and why there aren't many people in the pretrial supervision program now. Because that's the question that keeps coming up in the committee, right?
Yeah.
So we need
Trying to
to
figure it out.
understand the moving pieces, and the defense counsel is part of that, as is the prosecution. So is there, can you weigh in on that, Matt, in terms of what you're,
That one issue?
Yeah.
Sure, say something.
So why don't you come out?
I didn't mean to.
Oh, no, it's fine. We're just trying to juggle everyone's schedule.
I will tell you, it seems that in the last 2 days, the courts have been saving up dozens of cases that need reassignment. So I've got people sitting in jail for months that haven't had lawyers.
They now need the lawyers.
And I'm the one who does when the courts can't figure it out, I'm the one who does. So, I don't like having people sit there with no lawyers.
Right. So Matt, could you just identify yourself for the record?
Yeah, I'm not, I'm Defender General.
And talk about the defense role in the whole pretrial supervision program.
There's not much.
There's not much, but you're part of the court process when it's determined.
Yeah, all that really happens is we describe to the client what is available. And then, decisions are made about, what is in the best interest of that client. And the client ultimately decides whether or not they're going to participate in pretrial supervision or not. The thing about pretrial supervision, and I said this to Senator Sears at the time, is that none of this changes the constitutional requirements surrounding bail and conditions of release. And so this is an option that is available to people if people feel that is in their best interest to do. And the thing is, you can't really order it. You can't mandatorily say before somebody's convicted that they have to do pretrial supervision or pretrial treatment because they haven't been convicted of anything yet. So if there are constitutionally, if there are conditions of release that are sufficient to protect the public and first of all, really to assure your attendance in court, that's the main constitutional requirement of bail and conditions, and secondarily to protect the public in particular instances. And then the court has to put the least restrictive conditions that are available to ensure those two goals, which are both constitutional. Then pretrial supervision doesn't necessarily fit into the picture. So there are some people where that is number one in their interest and number two constitutional. And that actually boils down to a small number of people. The other thing is when this pilot was first put in, it was in Caledonia County.
Essex Orleans.
Essex Orleans.
Yeah, Essex Orleans. Yeah.
Right. And there just weren't many people who, I was told relatively recently there were like 4 people. Is it more than 10 yet? It's just a minuscule number of people who really kind of fit the profile of the people who would either agree to be in it or would constitutionally be required to be in it. If the question is, why are there so few people in it? I think that's why. And I also think, the county that it was started in was started with very modest expectations to begin with. And it just didn't, I know that the idea was that there would be something akin to like the federal program of pretrial supervision. But our Constitution's different. So it doesn't match up. And what is going on in Chittenden, like when you compare apples to oranges, they have almost nothing to do with each other as a practical matter, because the folks who were brought into that court have like long-standing history of multiple charges, and their cases have been delayed for really long periods of time. They weren't getting any services at all. Part of the issue was, they wanted to voluntarily connect with services to try to get themselves out of the cycle that they were in. And there were some number of people who were in that docket that opted for the due process side of things because maybe the arrest was bad, that there were constitutional violations. They didn't do it. Amazing that might happen on occasion. But, the bottom line is there are some number of people
who opted out and went, who said, I'm not doing, I'm not doing the, accountability court services route. I want to try. And they did that too. The thing is that the backlog was so great. There were so many people with so many dockets in Chittenden County that, we got rid of hundreds of dockets during that 3-month period that it was operating, just by sheer force. The fact that there were so many that were delayed for so long that the court wasn't getting to. And it was very simple as to why it was. You got an extra judge, you got an extra prosecutor. We dedicated particular resources for it. I put $50,000 into social work to assist the clients to connecting from what the court order was to what AHS and BOC wanted to do. And so when you throw a bunch of resources at a particular docket, you're going to get a positive result. And it was a positive result. Nobody should say anything different when it comes to that, but that's why it happened. So very different than this. Then the thing that I was going to say, which I don't know what the changes are going to be, and I warned Senator Sears about this, and I think I did it with you folks too. You can't legislate around the constitutional requirements. You can't change the Constitution by putting other factors that are not constitutional as part of what you'd like to see people do, because they can still stand on those rights, and they have to make decisions about what's best for them in their particular case. And the lawyers can give all the advice they want and say, hey, this pretrial supervision situation would be very good for you and might be good for your case down the road. And if the client says no, then it isn't going to happen. I think there was a confluence of those events, and it really wasn't particularly, I didn't know if the resources were really available up there to make it work. Well, that's one of the keys, it's just that you can't add criteria that are not constitutional to force people to do things that would be unconstitutional. And so that's why there aren't very many people in it. I think there would have to be, I don't know what's going to happen next. I do think, honestly, that what we did in Chittenden County with the multi-docket cases and those that have been delayed for a long time, and people with mental health problems, drug problems, co-occurring disorders, and the like, the people who are ready, willing, and able to do that, notwithstanding anything that has to do with their criminal case, that can be exported around the state, and you're going to get a lot of bang for your buck, as long as the people are resourced to do what needs to be done. The treatment resources, prosecution resources, the extra judge time, and then I have to deal with the social work connector. If I were going to run it in Chittenden County all year round, it'd cost me, about $200,000 in Chittenden County. I put $50,000 in, and because I knew it was a short amount of time that I could do it. I don't have that budgeted to do that. And this came up on short notice, and we did it. And I was talking this morning with the House Judiciary and Senate Judiciary. They had a joint meeting, and they're like, well, can you build that program? And I can build. I can give you budget numbers of what it might cost, but I can't. Lamoille County doesn't have the Howard Center. Other counties don't have like the treatment resources that Chittenden County has. They also don't have the number of, Lamoille County has 2 public defenders in it. Chittenden County has 12 in the staff office alone. So when I say one of you is going to be just doing this court to deal with this connecting these clients, if they want to do it, I can do that. If I want to do it in Addison County, there's only 1 public defender there. So the arms and the legs are just doing the, you can't split off. So it entails, there's a diseconomies of scale that goes on with some of these counties because they're so small, you can't do it. And then you have others where it's more feasible, the kind of Bennington, Wyndham, Rutland sort of thing. And then, then you have the issue of the contractors who, they're independent contractors. I can't order them around the same way I order around staff attorneys who, are direct, they report to me directly and serve at the will of the Defender General, as they say. I have some influence on the other ones, but, we have contracts in place that define the type of work they do. So, there are impediments structurally. The bottom line is what went on in Chittenden County did work. This has struggled, in my view. They're trying to get at the same problem, I think. It's folks who have not received the kind of services. And it's not just mental health, substance abuse. It can be, I see it more broadly. It can be housing, it can be employment, it can be childcare. It can be all of the things that are an impediment to you. Number one, showing up in court. Number, transportation being another one. One of the things in Chittenden County that went on is the business that I contracted with to handle this. They were doing after hours stuff. There's a drop, so they could drop in if they were homeless or transient housing or whatever. They had a warm place to be. They could the clients, they could go in and get soup, they could get coffee, they could get snacks. They had a place to go to talk to somebody if they were doing badly. That is totally outside of anything else. So it's like this safe place sort of to be. But they were doing this on weekends. They were doing this after hours and the like for the money that we spent. So I think money very well spent. But it's that kind of thing that connects so that in the interim, while people are trying to find a place to, not be freezing and not hanging out in doorways and causing trouble on Church Street, that kind of thing, they have a place to be. So it's not just about compliance with a condition, it's about putting you in a position where you can comply with a condition. It's not, some of these folks, literally, if a court had ordered them, and I said this at the beginning, and why I brought this $50,000 of services to bear was you can have a client who wants to connect with AHS services and the court orders it. And then they leave the courthouse and they literally can't figure out a way to get from Cherry Street to Williston to do whatever the screening or wherever it is they have to go. They don't. And these folks with the company is Therapeutic Works would literally pick them up and drive them there. But, it's more than just what they call this warm handoff of people who need stuff. It is, they did a lot more than that, but it can be as fundamental as that. They can't get there, so, I think the idea of pretrial services has to be looked at differently. It's not about what you order people to do because you just set some people up to fail. It's how we can connect those people with the services. It's not that the court order is wrong. It's not that some of the services aren't there depending on where you are. It's how do you get that person from here to there? So
if we're looking at the pretrial supervision program, it's what we are looking at. Would you, I don't want to put words in your mouth, Matt. Is it worth us? Is it worth our time and resources on the state level to continue with pretrial supervision and or to expand it to other parts of the state if we don't beef up our community partners?
I would go about it differently. Some counties don't have the treatment resources and the like available to them to do the things that might be ordered in pretrial supervision. DOC might not have the resources to do what it needs to do for pretrial supervision. I know they have trouble doing what their fundamental core obligations are. When it comes right down to just literally just hiring people. To me, it's the connection of the judicial system with the treatment system, even if the treatment system exists. So on some counties, you need more as far as the treatment side. But I think in almost every county, you need to have that connector between what the judge orders and what is available for treatment. And in some places, like with the co-occurring disorder issues, we don't have any place in the state that does that. There is no facility here. So, you know, we've done work to get people out of state to New Hampshire that has a couple of different places that handle clients with both the mental health and substance abuse, co-occurring disorders, and other issues. They have been some of the more hardcore kind of problems, but they've had really good success because of that. Small numbers, but we don't have any place that deals with that on a residential basis in Vermont.
So what is in the governor's proposed budget? It's in the general fund. There's $200,000 to expand this program,
Which program?
pretrial supervision.
Okay.
And the proposal is to have 7 permanent positions, new positions. I believe it's new, I'm not sure. In the office up there. And we have to weigh in as a committee. Is this something that we support? Is it something that we should be investing 200,000 in or not? We're gonna have.
Sounds like a really small amount of money.
Well, my question is, we put in 600, and I haven't gotten an answer to this. We put in 600,000 in FY '25 to start the program of pretrial supervision.
600.
600,000. Senator Sears got that in the conference.
Okay.
Appropriations. 600,000. Now, I haven't gotten a definite answer. Was that in the base? Or was that a one-time? So if it was in the base,
That was in corrections budget?
yes.
Okay.
I think it was in corrections.
Yes.
Yes.
Okay.
So if it was in the base, you'd have another 600,000 in FY.
You're talking about 800 total.
Well, if it was in the base,
Yeah.
it would be there again in FY '26, so that's 1.2 million. Because you got 2 years in the base.
Oh, okay.
And then additional 200,000 brings you
It
to,
hasn't been, I mean, I'd have a
Question
whole
is-
bunch of questions from a budget standpoint, but
but if it's a one-time for 600,000, there's already been some money expended from that. And then they're adding 200,000. What are you adding it to? The 600 or the 1.2 million? I can't get an answer for that yet.
well, you know, the number of cases that went through this is,
Minimum.
yeah, I mean, I don't want to ask them questions like, you know, that I don't know the answer to. That's a lawyer thing. But
We're trying to
we
figure
didn't
out,
spend $600,000 on like 5 people, did we?
no, I mean,
I
they've
don't think
expended
so.
some. They've expended some.
Yeah, I would imagine.
600.
And
But
I'm
even,
not even sure for what.
right, but even if there was 500,000 left in that,
Mhm.
and then you add another 200,000 to expand it statewide or other parts of the state to hire 7 permanent PMP officers.
Well, what kind of numbers are you going to get?
Well, that's our question. We don't know. We don't know.
This is like a layer on top of layers of things that already exist, some of which work okay.
So we're trying to figure out, where do we spend that kind of money? Do we continue spending it on pretrial supervision, tweak the program? Or do we just say, repeal this program and do something totally different?
I mean, I know that we did hundreds. I understood, somebody told me, the attorney who I assigned up there Now dockets is not the same as people,
Right.
but that they dealt with over 600 dockets in basically November, December, January, were moved off of that list in Chittenden County. And clearly not everybody was connected with services, but bunches of cases were dismissed. Others were resolved. Some people were, a bunch of people got into treatment. Everybody really agrees that that was successful. And I spent $47,500. I don't know what administration put into for the court to have the retired judge come and provide more judge time. I don't know how much money, if any, was appropriated to deal or redirected to deal with Zach Waite, who was the prosecutor. Now, he was already a prosecutor in Washington County, so I don't know if they just kind of took that and like reassigned him. And it didn't cost any more money. But we got a lot of bang for the buck up there doing that. There were reasons why we did, I think. Chittenden County was a good place to start and try that. If we'd done it somewhere else, it might not have been as effective, but it was quite effective. So I'm just wondering, cost effectiveness, but I don't know what the plan is.
That's what we're trying to.
That's the thing, if the governor's recommended budget has this money in it and there's a plan that I'm not aware of, then I'm not commenting on what I don't know about.
So what I'm aware of, what's in the general fund budget is 200,000 for 7 permanent PMP officers. And what we heard from Jay Johnson was to expand the pretrial supervision program throughout the state. So my question is, do we?
But it's not but it's 200 on top of something else.
Yeah, and I'm trying to
We don't
figure
know
out
what
what that
something
something else is. But is it better off to expend that money and do replicating the court accountability? Because if you looked at that, you only have one person on pretrial supervision. Is it worth it to invest this kind of money in a pretrial supervision program? Where if you invested it in beefing up your community providers to help that wraparound service and make a connection with the judiciary, is that a better place to spend the money? But it's going to be more than 200,000.
If I understood the plan about pretrial supervision better, like maybe this, like I said, there's something like on its face, it looks like it'd be much better to do something like we did in Chittenden County, and DOC was at the table during that stuff and they did a good job. AHS was available. We had people connecting people. It seemed to work. What the pilot project didn't do very much. I don't know what you learned from it. Aside from what I kind of thought might have happened is that constitutionally we weed out a whole bunch of people pre-trial so that the program almost inherently wouldn't have very many people in it.
Put them somewhere else. Kevin?
Is the accountability court still working now at this point, or did that stop because we ran out of funds?
I don't know if it was funds.
3 months.
It was 3 months, and so the idea was to get at this,
Yeah.
these things, and it's as it existed, it doesn't exist anymore.
Yeah.
What they are, I believe, trying to do is designate one day, it's like one day a month,
Right.
to deal with kind of what's left, and I don't know what's going to happen with that. The TWI who I have under contract, I had their contract extended a month after the court stopped to kind of see the people through what was ordered in the prior month.
Right.
But they're going to be off contract with me also at the end of February. So their contract runs through the end of February.
So once again, I can't put words in your mouth, but what I'm hearing you say is if we could extend that accountability court for a period of time, it's been successful, it might continue to be successful.
I think that in some many counties, it would be beneficial. I know that it did something useful in Chittenden County. I can only see what I can see, like there were hundreds of dockets resolved. That seemed to do something, seemed to work and connect people with services. And it actually resolved the cases. It wasn't just pretrial. So it's not while we are lingering until our case resolves, it helped resolve cases because the whole point of it was, to get these, once the people got into the services, good things started to happen. And the criminal justice system became much less important than the kind of treatment side of things. So, I saw that the benefits of that. I've heard the same things about pretrial services that, there wasn't much to say because there wasn't much going on.
That's what we're trying to figure out. Do we continue this pretrial supervision program? We redesign it, or do we say the money should go into providing more beefing up of services in the community? Brian?
I was just flipping back through notes. It was about a month ago that we were talking about this before. At the time, I think it was the case that there were like 4 dozen people who had gone through the Chittenden accountability docket, whatever we're calling it. And that represented about 400 cases. And I think testimony at the time was that was about a third of those who were eligible to go through this kind of thing.
Yeah.
And so the question is how many remain? And
then we had another month.
Yeah.
Since then, and then it shut down. And so like that makes sense when they were telling me it's over 600 dockets were resolved. And then there are going to be more that are not dealt with in that way. But yeah, it makes sense.
But to Kevin's point, I mean, where do you put the resources? I don't know how many more people, if you keep putting resources into Chittenden, say, are going to be good for this kind of a program.
Yeah. The only thing I can say is, and I said this, thank God things have changed a little bit since the first quarter. First quarter of fiscal year 26 for us, Chittenden County saw a massive increase in caseload, like unbelievable. And I was like, if this continues, we're going to have to like double the number of lawyers we have, and they don't exist. So whole other issue. The second quarter, however, in public defense, it dropped precipitously, and we are, when you compare the first half of last year to the first half of this year, we're about flat. So that massive spike that occurred the first quarter of 26 did not continue in the second, thank God.
Yeah.
But the people who are in that first quarter are not in the backlog yet. They haven't dragged out, they haven't done the 6 months, 1 year kind of thing that gives rise to all these violations. So down the road, I think you're gonna have plenty of opportunity to deal with these people in the next, 6 to 18 months. We just haven't got there yet because it's too new. I think this because I've talked about this many times here, but I've kind of a math guy in some ways, and long ago I developed this algorithm to do predictions on caseload, and like the first quarter of this year, like it just blew the algorithm out of the water. It was like nothing was matching anything. The only thing I can say is that the second quarter, now it all seems to work again. So I was like, boy, I hope this is a blip. And it seemed to be, but that doesn't mean that spike is not going to carry itself through the system. And then you're going to have some of those issues down the road. I know that my lawyers were feeling the problem seriously during that time frame. But so bottom line is it worth continuing in Chittenden County? It probably is, because
Accountability for it,
Accountability.
right.
not the.
Yeah, that I know about, I think with the data that I'm aware of regarding pretrial services, I wouldn't spend another dime on it. However, it might not be fair to evaluate it based on such a small sample size. And I just don't know what the overall plan is. I think that the constitutionality thing kind of whittles your potential population that would be good for pretrial services. And how you have to deal with people before they're ever convicted of it.
That's the issue.
Yeah.
That's the issue. Yeah.
I mean, I chased off your.
Well, she had to go it too,
Yeah.
so it didn't matter.
This is very helpful.
James?
No, I walked back in at the right time. I had a phone call, sorry, but that my question was going to be is whether or not you felt personally it was worth continuing this program or what the likelihood of uptake is, because everybody I've talked to, it doesn't seem like it's got a lot of potential for many of the reasons you listed before I left the room. And so
You know, the only thing I can say that I will say as far as keeping an open mind on it is, I don't know if the sample size is big enough for me to comment. Number one, from what I've seen, there was not much to see. And so, but there are plans out there that I've not been consulted about. So if there is a plan, you know, I'd be interested.
All I know is an additional 200,000 to something and 7 permanent PMP folks. And what
I mean, I'm sure they could use that anyway.
the administration said was this pretrial supervision.
I mean, one of the things I saw in the bill was that they wanted to have a caseload of 20 per person, right? That's what for pretrial. I would be, and what did how many were supposed to be? 7?
7.
I don't know if you get 140 people statewide on the thing. You might get 40. I don't know. I don't know the answer.
I think we know the answer either, and that's what we're trying.
But I know where this came from. I know what Senator Sears was looking at. And
Repeat it. People just certainly.
well, but the idea was that the federal system, and he saw there was a thing that they did in Illinois. That was one thing. Of course, I told them at the time their constitution is totally different, which it is on, ours is different on bail and release for some historical reasons that I'm not going to go into. And then they looked at what the federal system has done. And then there are other models where probation and parole is not part of the Department of Corrections. It's actually, like in Massachusetts, it's the court is enforcing its own orders with probation and for the Department of Probation. That's where I started many years ago, 40 years ago. So they're like different models. So we're kind of mixing concepts with the idea that if we could kind of help people get through these things, it'd be better. That it just doesn't seem to fit our constitutional structure. So anyway.
Well, we don't know what we're going to be doing.
Okay. Well, let me know when you do.
You'll know. We'll have you back. Don't worry. Have you back.
And if anybody does, if there is some plan out there, I would be happy to look at it.
We'd be happy to look at it too.
yeah.
Yes,
Except for 200,000
very helpful.
without
Very, very helpful.
structure behind it.
Anyway.
Anything else for Matt?
I mean, it's a tough issue.
Yeah.
I appreciate the fact that people are making an effort at it. We've come to a different time, I think, in the criminal justice system than we've been in the past, dealing with different issues, with different kinds of people, different problems. So we're all struggling a little bit at how to get at it. The Chittenden County thing did seem to work.
But it was,
work.
Matt, you and I have been around for quite a while. This was no different than Council of State Governments Justice Reinvestment One.
Right.
It was no different.
No, I mean,
Put the resources in the courtroom to help the person get hooked up with the services.
right. I mean, we were taking somebody who has cancer, you focus your treatment on the place where it is, and you're going to make some progress, probably. Not with everybody, but probably. That's what happened. And so I have nothing bad to say about that. Some of my contractors might feel otherwise just because they got pulled.
They got pulled because you didn't have enough staff.
Well, and the staff people are a different issue. The staff attorneys, I can tell them what to do. The contractors, they, by definition, have to be independent contractors because there's a conflict with the staff system. They also have multiple contracts, so they handle in different counties. So they can't be available at the whim of the court saying, hey, your client got picked up, show up. And, your office is in St. Johnsbury, which one of my conflict contractors in Chittenden County is. Can't do it. Similar with the other ones, but they happen to have their offices in Chittenden County, but they also handle contracts in Addison and Orleans and Moyle and other places. So they're a little bit different, but we had enough cases in the staff system alone so that we could focus resources and make it work. I don't want to make it sound like everything was perfect with that. Well, it wasn't perfect, but we made a lot of progress. And, if ultimately we get, if we reduce the recidivism rate of the people who went through by connecting them with services where half of them succeed, that's massive success where half succeed, and then maybe we do better the next time for the other 50%. I don't know. All right. Well, thank you for the time.
Thank you, Matt.
Thank you.
We really appreciate it. We'll call on you again, know where we're headed, if they know. I think I'm gonna ask DOC to come to the table. I don't know who from DOC will be coming up. Gary, you've kind of heard the gist of this. And as you get settled, I'm gonna ask Haley a question. Do you know anything about the money because it goes to DOC's budget?
Yeah.
Do you know anything about that 600,000? Was it there just for FY 25 or was there also 600 in FY 26? I don't think there was.
So there are two options here. I have been looking at this for the last couple of minutes. I can take my best guess or,
But don't hold you to it.
yeah, or we can address it again tomorrow morning during budget testimony. So I'm gonna let you make that decision and
Why
I.
don't you give us your best
Okay.
guess and then that lays the foundation for tomorrow.
But it won't be,
But we
the
want to
same-
hold you to it.
but it won't be the same information possibly.
Well, Haley may not have all access to all the information. So the question is, folks, is so you can follow it through. FY 25, there was 600,000 put in for pretrial supervision to begin the program, to roll it out slowly and see what the results were before there was money put in. The question is, did that 600,000, was that there just for FY 25 budget? Or was it put in DOC's base budget, which then would be another 600,000 in FY 26, knowing there was a little bit expended of the original 600,000 in FY 25?
To the best of my understanding, so in FY 25, Senate appropriations added the 660,000 as, in line with the legislation that was passed to establish pretrial, starting with the pilot. I believe that was added as one-time funding, and then in FY 26, the governor included 650,000 in his recommended budget as base funding, so that those positions can continue to be funded every year.
And did that pass through?
Yes.
So there would be a potential of 1.25 million, of which some of that has been expended,
Yes.
which then for the FY 27 budget with the appropriation, what the governor is proposing is 200,000 on top of what's left of that 1.26 million
Yes.
to carry it through statewide, which of that 1.2 million, whatever may be left, would be also running the program, but also hiring 7 permanent positions within P&P. That's your understanding at this point. Tomorrow, that could be different.
We're gonna hold you to that, Haley?
No, we're not gonna hold her to it.
But ideally, yeah, there would be one pretrial supervision officer in each of our 12 district offices.
folks clear on this? Clear as mud, Brian?
No. And I know we don't have all the answers, but,
You got DOC sitting there that might help too.
and I know they're not official and firm and all that stuff. So I think you said FY 25 660 one time,
Yes.
and you said FY 26 650 base.
Yeah.
And now we're adding 200 and we don't know if it's base or one time.
Well, that's six. I'm just. So it's more confusing now because
Sorry.
they initially put in 660,000 to start the pilot
In 25.
in 25. In 26, so that 660 is eventually going to go away because it was only there once. But it's eventually going to go away. In FY 26, there was an additional 6, right?
600.
650 put in. So you're at 1.3. Right? 1.3 million. Some of that's been expended.
For the second go around, the FY 26, the 650 is base, right? So it's gonna be again and again and again.
In 26, yes.
Yeah.
So there'll be a one-time bump of 200, what's being proposed is 200,000 in FY 28.
Yeah.
It will be added to that 660 and the 650. But we know some of the 660 has gone down because we've been doing.
Yep.
So for 1 year, we'll have a bump of 200,000 on top of about 1.3 million. In FY 29, that first 660,000 may be totally gone.
Yep.
So then you're at 800,000.
Because the 200 is gonna be ongoing.
Yeah, I think that's in the base. It's gotta be if you're gonna hire 7 permanent employees, it better be in the base.
That's a question too.
That's, I believe that is accurate.
So then you're gonna end up with about an $900,000 program.
Yes. And I guess the,
I don't understand how you can have 7 FTEs on 200,000.
No.
that was my next one.
1.3 million.
Right. That's what it really is, yeah.
So this 200 is not for adding
So-
7 people.
But the logic then.
Well, that's what is explained in the budget.
Mhm.
That's how it's explained in the budget. We had Jay Johnson in.
I remember, but then they gotta be fractional or something. How much are we paying them?
Well, let's go to DOC.
Yeah, all right.
Let's go to DOC. They may help us. Gary, help us. Help us, help us. Both of you, help us.
Hi, Gary Marvel, Deputy Director of Field Service Division, Department of Corrections.
I'm Maria Godleski. I'm the Assistant District Manager at Burlington Probation and Parole and was attached along with PO Nate Hudak to the Accountability Board.
I could provide a little clarity. It's going to be somewhat limited because I'm not the budget guy by any chance. The original,
More limited than what we've already heard.
our original understanding was that the rollout was just going to go statewide and that we need the funding to be able to hire those positions. And that's what we were going to do. And then we kind of got derailed by a few things. One is that we had severely low turnout. We had about 15 referrals in Newport. We ended up putting 8 people on pretrial in Newport. Then we decided to roll it out as part of the accountability court. The Defender General's point, I think one of the things that happened was that a lot of the things, the wraparound case management that would happen as a result of pretrial was sort of subverted in a good way by the accountability court because they're sort of competing support resources in a way. In other words, we were doing the same thing that we would be doing on pretrial through the accountability court. So I think it kind of worked what the potential utility of it is. And then the last piece I brought up last time I was here was that, I don't think we've necessarily figured out how to incentivize it so that all parties are interested. I've looked at the most recent draft. I see, there's some proposals to change the referral process so that we're able to do referrals. We're in support of that. We're in support of the lower caseload. Obviously, if you're looking at a caseload cap of 20, that completely changes the supervision model. It would have to, because there's no justification for having we were really taking into account that it might be a lot of people initially, because it was I think when we looked at the original numbers, it was in the hundreds and hundreds that would potentially meet the criteria around the state. I think it was up to 1,000 maybe that could have met the criteria at the one condition violation or 5 dockets pending. So we were kind of anticipating an onslaught if we were to do a, full rollout around the state like we originally planned. So I think the model would have to change dramatically if we were to execute it differently. If we were to do it in different parts of the state, if we were to do it in the fashion that we'd have only 20 cases per caseload, I think you'd be looking at more sort of like the FACT model that was brought up by CSG. That would probably make more sense, which we're also doing in Burlington. That's a wraparound case management service where we're providing a lot of support, we're meeting with people regularly. That just would make more sense. I'm trying to think, like right now, it looks like if you got rid of I think that was one of the proposed, that you got rid of the violation of condition release requirement and the 5 docket requirement. And that's the proposed draft. At that point, it looks like the criteria would essentially be who we recommend. Right now, our recommendations based on 4 factors, and Maria, fill me if I'm getting this wrong. You need a Vermont residence because you need to be able to be supervised. You need to be able to participate in the telephone program, because again, we're relying on potential for telephone reporting. You need to have no holds, nothing that would make you incarcerated. How you participate in pretrial if you're in the facility. And then the last one is you can't already be on community supervision because that'd be redundant. Like if you're already on probation, there's no reason to be on pretrial as well. So that's it. I mean, like other than that, we can look at anybody that is in the system that is, potentially that the court or anyone else is interested in having us look at as a potential for being on pretrial. I think the violation process, being able to file it directly with the court, it would certainly speed up things in terms of the response time. We've only had 1 person on Burlington, so I've had to kind of rely on reports telling me that was kind of a clunky process. And there was also some issues with, you had dual paths when someone would be violated on their conditions of release by law enforcement. At the same time, we would be filing a violation with the state's attorney's office because there was nothing telling law enforcement they were on pretrial. So they had to figure that out. So that was one of the things that we'd want, is to make sure that those conditions would be, the pretrial supervision would be one of their conditions of supervision or conditions of release, so that the law enforcement would be able to see that that's part of their experience. That's all I got. I mean, is there any other things?
Well, what raised concern with me was the 20 caseload, 20 folks per caseload. Since statute, we already have some caseload ratio requirements. So that would have to be looked at as well, because that would throw that totally out of whack, depending on the risks of these folks. Because your caseload ratio right now for your officers, if it's a high-risk person, your caseload's going to be less.
Right.
A low-risk person, your caseload's going to be higher.
So it's 45 for risk management, which are people that are just not on telephone. If they're not on telephone supervision, they're not low risk, they're going risk management. And the risk varies in that population pretty dramatically. If it's somebody, a youthful offender caseload, it's 25 is the cap. And again, I think the thinking CSG, kind of going off their presentation, was that these are people that are inherently in a more unstable situation. They're not adjudicated yet. They don't know what their legal status is going to be. So the thought is that they're going to have high needs. Again, that's also the idea, is that you'd be identifying people that have high needs and are inherently unstable that need that wraparound support.
Let me ask this question while it's in my brain.
Yeah.
Would DOC be the appropriate place to have as a hub to hook the folks up with the community partners? To make sure they're attending their programming or can get to where they need to go? Is DOC really the place for that hub to occur?
I think to answer that, if the question is, could we do that for all people pending something, have a docket with the court? No, I don't think we'd have the capacity. I think that would be way too many people, no matter how you funded us. If you were to make that criteria a little bit more stringent, depending on how stringent, we could have a role, because that's essentially what pretrial is. That's what pretrial supervisions intend to be, is that we're connecting those folks. The model that we use and the level of service that we provide is going to be dictated by the resources. The amount of resources we get is going to determine the number of positions we have, and then we would put those based on the need, based on where we're getting the most bang for our buck, I imagine.
I think like what worries me is adding positions in a staffing crisis in corrections. So I was wondering if you could talk about like, how's recruitment going generally in probation parole? And are those roles usually filled by people who would be in the facilities? Because we could be shifting, one problem to another, that's.
Yeah, it's a complicated landscape. It's certainly, to be very clear, it's not the same issue we have with the facilities. That's a much more challenging hiring situation, and it's always been that way. It's just gotten worse, and nationwide it's gotten worse. I don't think we really have too much of a hiring problem on the field side. It's certainly not as robust as it was when I started, and we get like 60 applicants for one position. But I mean, Maria would know better than I do because she does hiring in Burlington, but they're still getting applicants. I've never heard of anybody not getting any. So I don't think we have an inability to hire.
But are they coming from facilities? Because I don't want to be creating more vacancies in the facilities,
Some of them
do that. Yeah.
Yeah, some of them do. Typically, the CCO position is the most common that comes directly from the facilities. Sometimes you get somebody coming from facilities as a caseworker to be a PO. It's fairly rare that you go from being a CO to a PO, although it does happen. At least nowadays, it seems like we generally want someone with more case management experience before you make that leap. So I don't think it would be quite the flow directly from the facility as we might fear.
Thanks.
Questions, folks? I don't know what direction to go. I really don't. So the governor's proposal, 200,000 additional to the program with the intent to hire 7 permanent P&P. How would that be spread out across the state because the goal is to expand the pretrial supervision with those employees with what you already have. So how would that play out?
We'd have to figure that out. We don't know yet. We have not determined where the next site would be because a lot of it depends on whether or not the statute changes, the criteria changes, how much funding we get. But I would tell you that it would make sense to me that we would look at what the package is and then we'd figure out from there where we're going to be most effective. So I would imagine, I want to also say that I think in some ways we haven't even really started pretrial yet because you have, one area to the Federal General's point where there's just not that many people in general. Then you have one place where you had a completely different system running parallel to it that, like I said, was kind of doing the same thing. It would look very different in Rutland or St. Albans, or, and the needs would be different and the population would be different. And I imagine the court's discretion on who should be on it would be different. You might just get a very different landscape depending on where you go.
It's not up to the court to say you're going. According to the Defender General, it's up to the defendant.
It's a voluntary program.
It's voluntary. For that, because they haven't been found guilty. That's what we have to remember. They have not been found guilty. So we're asking folks to be supervised in the community. And they have not been found guilty. They're still innocent.
I will say in our office, the pretrial person was basically assigned to accountability court and they were assessing the people for pretrial to determine whether they were going to be appropriate. And even though we only had one, there were 6 assessments that happened and lots of other conversations with the defense attorney, with the treatment provider to say, hey, this is what this would look like. So we use the position for pretrial purposes, even though they weren't having a full pretrial caseload. And they were the liaison for the housing and the treatment and all of that, and appeared at the weekly huddles. And, the other day, the PO heard of a referral related to getting housing. He went right down and met with the person in Chittenden in the booking cell to say, is this something you're willing to do? Should we move this forward for you? So it was still being used at our office, even though we didn't have a caseload full of pretrial individuals.
Is that an appropriate use of corrections staff?
I mean, I would say it was the intent of the pretrial program. It was just being done by a different method. It seems to me like that worked well for that particular period while accountability court was operational. I think we wouldn't want to put somebody who isn't the pretrial officer in charge of that because it's essentially an analogous position. You're doing the same thing.
So I'm going to kick over to Matt.
I think it was absolutely essential. I think it was absolutely not appropriate. I don't know. it was absolutely essential for what happened in Chittenden County to work, that DOC be there doing that. And that was the beginning part. The next part was the connecting with our social worker to get them to wherever the house was. You know, if DOC was not at the table doing that, that would not have worked.
And why is that? Because that person's not under DOC. And how would DOC have that information that that defendant?
So part of accountability court, we had a weekly Burlington Care Team meeting and the defense was there, Department of Corrections, AHS staff, Howard Center providers, and we'd meet and there was a universal release. And if the defendant chose to sign the release, then we could speak freely about that individual, not just their public record criminal acts, about all of the things, mental health, medical, substance use disorder, and we could make a plan that seemed to the right fit for that person, not over supervising. Some of these people, though they've racked up charges, are low risk. The one person we have on pretrial actually scores low risk on our risk assessment. So, yeah, accountability court, I think it is continuing in Chittenden County so people could know. Even though Zach Waite's last day was last Friday, we're sort of in this break because there's some trials going on in the courtrooms, but it will be continued as of right now. Fridays, 1 day a week with Judge Kadams. So there will be a continuation of accountability court. And there, while they were able to get rid of quite a bit of backlog, antiquated dockets and sort things out with people with competency issues or who should be discharged because they're never going to be able to, or charges be dismissed, there's still more to be done. There are still people with old dockets. Even looking at the court calendar today, there were people with dockets from 22, 23, 24. A lot more 25s than there were before on the regular docket. But certainly there is still backlog of things that are not murder or sex offenses or something that would require a lot more intensive labor on behalf of the two attorneys.
So we're working in total with, I'm just going to round this around 1.4 million. Because if you add on the 200,000, would it be better to redirect that 1.4 million from, it's all in DOC's budget. But would it be better to redirect that money to really expand the accountability court model versus putting it into pretrial supervision?
I think there's a lot of different ways to skin the cat. I think you could.
Be careful with that term.
Pro animals, so.
Not literally, but I think there's lots of different ways you could go about it, but it's really what we're talking about is comprehensive case management with a forensic population. And our staff are nimble around that. I would say we're the best in the state at it because that's what we do. And we have to be nimble based on how long somebody's going to be on supervision. It's driven by the conditions of supervision and the time frame. So like if somebody's on for a 26-week DBAP, we have to get that done before the probation order runs out. If we have an accountability court that wants us resolved in 2 months, we'll get it resolved in 2 months. And if we have to coordinate services into that timeline, we will. So the question is like, will we have the staff to do it? And that really just comes down to the funding.
Kevin.
So one of the provisions in here is the pretrial supervisor or supervision officer shall notify the prosecutor that use reasonable efforts, blah, 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 and conditions of violations of conduct, court imposed program conditions, right? So to notify the prosecutor. And we had a conversation the other day where some people advocated for it to be or the court. So as you guys have to deal with this, you know, currently, I guess, for however many people you have in the program, 1, 2, whatever, have to notify the prosecutor. Would it be confusing to have, or how would you, this is better, how would you get all of your staff to report to the same entity? So some aren't reporting to the prosecutor, if this bill went through the way it is, some reporting to the court, some reporting to the prosecutor and hoping for the best that they talk.
It'd be dictated by policy.
You would make.
We'd have to have a policy, right? Like we have a policy right now for pretrial, but the criteria, the statutory language change, we'd have to change it. So we would just dictate it by policy and our staff would follow policy.
The reason I'm personal, if it's going to be both, it should be and. So it's not like, but if you guys are going to you can commit to taking care of it in policy, because it just doesn't make any sense for me to have people reporting, half of your people reporting to the prosecutor and half reporting to the court would be a.
This is a policy decision because there's two versions out there. Council of State Governments has recommended the DOC, right now you report to the prosecutor. Violation conditions up to the prosecutor, bring it to the court. So right now you could get a different prosecutor in different counties recommending different things. Council of State Governments wants DOC to be able to go right to the court. There's not an or, they go right to the court. The administration has proposed that DOC could have that flexibility of going either to the prosecution or to the court. But we haven't decided, we're working on pretrial supervision, we haven't decided which model.
And I get that. I just want to know how they would handle it if it was left to be gray.
I mean, it'd almost be more work to not notify both parties.
I would just say copy one.
Yeah, because we would just do it anonymously.
I mean, you answered the way I wanted you to answer, is that you take care of it in some kind of way that you wouldn't let this gray stand.
With regular violations and conditions release of a person on probation, we are notifying the state's attorney's office and then they are choosing to prosecute because it's a new charge. Just like a police officer saying, here's a charge. They're deciding whether it meets the threshold, whether the affidavit needs to be bolstered. So certainly the prosecutor needs to be involved, but we want prompt response. If this program is so short or intensive, we would want prompt response. And so including the court would make sense to me.
Yeah, I
Or
mean,
going directly to the court to begin with.
right. That seems to me like the most sensible way to go about it, because that's typically how we operate. I mean,
It's just my question and you answered, like I said, I just want to make sure that somewhere along the line, if could be completely different language, but that gets to you. I just wanted to hear you guys say that if it was an either or situation, that you'd handle it so that your people were all doing the same thing, regardless of what that is. So
yeah, no, all that would absolutely has been historically and would be continued to be dictated by policy. We'd have a directive, and that's the process would be laid out there.
Kevin and then Mary?
You know what, mine was an editorial comment, go to
But so how would we ensure that? Not that you're going anywhere, but when you leave, the next folks follow your process.
Well, the directive, there'd be no incentive to change the directive that I can think of, unless the statute changed again. I can also tell you, we're in no hurry to change more directives than we need to. We have quite a few that we've been trying to get caught up on. So,
you'd like to settle in.
yeah, it's a lot of work to rewrite a directive. It takes a lot of back and forth. So we don't do it arbitrarily. It's really only when a need emerges.
So I think the big question before the committee, and we're gonna just don't know how to approach this, because we have recommended language changes to the program pretrial supervision. We've got recommended language from the Council of State Governments. We have some from the administration. Some of that's the same and some is quite a bit different. Now we have a layer of discussion that we need to figure out. Do we continue even with this program?
I do have a question now. My understanding is the accountability court was basically a governor
It came about,
executive.
well, it came about because there was real concern about public safety in Burlington.
Right.
I had a conversation with the governor and the administration. And the administration put this together back in October, I think it was October,
With the mayor.
with the mayor of Burlington to really help public safety issues. So this was just kind of a little
Right.
Pump in the arm.
pump in the arm that just kind of happened for 3 months.
Yes.
And what is happening is it seems, which is no surprise, because you have the partners working together.
Right.
And you have the community providers coming to the table.
Right.
So now it's gone away because it was only for 3 months. Because state's attorneys had to pull a state attorney from a county. The defense counsel had to juggle within their world to find a defense attorney available. The court brought in a retired judge specifically to work through those dockets.
It's reduced, but not going away. It's going from 5 days a week to 1 day.
But there's resources being put in there.
So you went from an adrenaline rush for 3 months now you're only doing it 1 day a week. I remember the adrenaline comment. Last time you were in, you can only work on adrenaline so long. My question is since the governor had this, sounds like a good idea, initiated it with funding, we see some success. But he's recommending we put money in the pretrial supervision instead. I'm wondering why he didn't continue the accountability course rather than the pretrial.
He sees
I'd
the
like to ask that
pretrial
question.
supervision, he sees the pretrial supervision program as part of the accountability court. Because that got moved from Essex Orleans when the accountability court started. They moved the pretrial supervision from Essex Orleans County to Chittenden County for the accountability court.
I would also add that pretrial is a program that the legislature created and mandated for DOC to expand statewide.
Right, but because the governor took the initiative of setting up the accountability court, he thought it was a good idea. It sounds like it was a good idea. Why he didn't say, well, let's continue the good idea, even though the legislature hadn't come on board yet. And that's the question I would ask the governor. Why are you riding two horses when you got a successful one here?
I think long-term, they attack slightly different situations because the accountability court was meant to be like a temporary attack to get through those cases that have built up. Structurally, it seems to me that pretrial would help to prevent that buildup because the idea, if you're looking at the purpose as it's currently stated, it's to get people to court and reduce the number of violations. Not getting to court and having violations is part of the problem, right? That created the need for the accountability court. So it seems to me like, you could have that as sort of a long-term intervention method that would help to keep that from getting built up again.
Good perspective.
No.
Okay, Brian?
Well, there are a few things, but I guess I'll stick to one, which is, I think early on in your testimony, Barry, you talked about perhaps there's a need to incentivize the use of the program, and I was wondering what that might look like.
I really don't feel comfortable speaking to what would incentivize the state's attorney or the court or the defense.
Yeah.
But it clearly is not currently desirable. So you'd get more referrals. There'd be more people being referred, and more people being put on. So I think there's things I could do to make it more favorable for the defendant. I think the defender generally would probably be the entity that could speak to that best. I don't know. But I was mentioning last time that we've had that kind of issue with a lot of these pre-adjudicated statuses in that A, it's a small population sometimes because of the criteria.
Yes.
And B, there really isn't a particular itch getting scratched. It's sort of like, it's an idea, and the idea is to help ameliorate a particular problem that we have, but it might not be the problem of the people who would need to be on board.
Yeah.
That makes sense.
It does.
Yeah.
Great.
I'm more confused than when we ever started. I just don't know how to go forward. I think it might be worth a conversation with all of you folks. We're before the House Judiciary Committee talking about the accountability court. And I think there is broad support. I think people support the concept of the accountability court. All agree that it was successful. The question is, what are the next steps, if any? I think it's a conversation I need to have with the House Judiciary Committee to see what their focus is. I just don't know where to go. I don't know where to go. I don't know whether to tweak pretrials, keep the pretrial supervision program and tweak it, or keep the pretrial supervision program and redesign it completely, or scrap that whole program and put the money elsewhere towards an accountability court that would be the DOC portion of it, but that there's a lot of other costs in there that the 1.2 may not cover.
I mean, I can certainly tell you that with the proposed changes, if they were put into effect, we would refer a lot of people because we have a lot of people to refer.
Break up that logjam.
We would certainly provide the level of case management, we provide with the resources we have, and we would do our best to get them to court and help them not violate. So we would do what was intended. How effective that's going to be and how favorable it's going to be the other entities in the system, I don't know.
How long would you know how effective that would be? A couple of years having it rolled?
When they resolve, really. I mean, if they resolve their, I mean, like, so if you're looking at the the assessment tool that we're using, the ORAS pretrial. I think a high-risk individual, so it assesses two things, which is their likelihood of making it to court, and likelihood of picking up another conviction of the charge. And in the high risk, it's like 17-15%, the breakdown roughly, which is, pretty sizable. So if those things don't happen by the time they're adjudicated, that to me would be a pretrial success. They don't pick up a new charge and they get that the charge they had adjudicated, resolved, we're done.
So you'd have some outcome and some measures to get there. The outcome. Well, we're gonna have more work on this map.
Mind if I add something?
Sure.
The question came up, why are people choosing, why are defendants choosing kind of accountability court model versus pretrial supervision? Pretrial supervision is signing up to be supervised for something to be violated for. The other resolves your case.
Right.
And that's the difference.
They want to resolve.
People don't want them signing up to be violated. Even if they go in with the best intentions. When they do the things in accountability court, their case might be dismissed. They might end up, whatever they were looking at before, their sentence might be a lot less. They're gonna get the services they need, and most importantly, their case is done. Nothing is done with pretrial supervision. So the closure of it is like an important incentive to do one versus the other. And so like there might be things you can do to incentivize pretrial supervision, but I do see that as being the ones for the very high risk, high need type people, as opposed to what was originally designed for the so-called accountability court. And I think that was one of the biggest differences, like my case is now over.
And that goes back to the testimony from the state's attorney's office. We have to determine who is the pretrial supervision for, the high risk folks or the lower risk folks, because that will determine. And what Matt, you were just saying is those folks that have a really high risk.
Well, I'm using this in a more general sort of term as opposed to high risk under the risk assessment tool.
They could have high needs as well.
Right.
Which cause them to not be able to make it to court.
Right.
Maybe
They're not huge dangers to the public, but they can't find their way to the courthouse.
But that would be the accountability court that could take care of that.
Well, it's both. The thing about the accountability court, like I said, is the closure. The only other thing I wanted to add was this: who reports? Like you report to the state's attorney, you report to the court. Reporting to the court doesn't do anything because the court can't do anything on its
Without
own.
the state's attorney.
It has to go through the state's attorney. If I just reported something to the court has no prosecutorial authority at all. They can't do anything. It's just like, oh, that's good to know.
So they'd reach out to the prosecution.
Well, it's a weird way to do it when the probation rule is not under the court. Like, see, that's where other jurisdictions and maybe council of state government was coming from.
Yeah.
Is where they had it attached. That's a whole different ballgame than the way we do it.
That right there is informative. That's learned a lot just in that sentence.
Brian?
I mean, this just goes back to the resource issue, but I think part of the reason the accountability court wasn't extended further is because it did cost money. It was just hidden. I remember you talking about quit money last time from people who exited your office, and you had something around 50 grand to pay for the services that were provided. There's a courtroom that we're taking up that you cannot have in other counties because it doesn't exist. They don't have a 3B. There's a prosecutor that was reassigned whose cases are backing up as far as I know, back where he should have been practicing. And then there's a judge coming out of retirement. These are all just hidden costs, not free.
Then it would be more than 1.2 million.
I don't know. I don't think so.
And I think another difference is the accountability court, in my mind, is everything's working in parallel as opposed to the normal system, everything's in series. In the industry, when we got into a problem, we were getting way behind schedule. We had real problems. You get a tighter team together, you get all the responsible individuals in one room, you figure it out, you got it done. Instead of everybody making telephone calls and setting up meetings, you just got together and fixed it. And you can't do that forever. But to get backlog down, to get through the real problem, the accountability court did that.
Going back to the question of like, who's this for? I think it's a really clear answer, honestly. I think it's the people that don't show up to court and the people that get into charges, really. I mean, that's really like what, those are the two risk factors that we're taking into consideration. And it's really one's a need factor more than anything. And we can guess that pretty well with the assessment we have, with the probability. We could tell you, moderate to high risk people of not showing up to court and picking up your charge. Luckily, that tool's been built.
And so, well, we've got to figure out what we're doing as a committee. As, while you're here, I'm gonna throw a question. It's not on anyone's radar, but it's percolating out. You don't have to answer it. You don't feel comfortable.
Set up for you.
Because there is a governor's recommend. Right now, for folks who are on probation, this midpoint review. Correct. Governor's recommend is to do away with it. The reason that that was put in was there were folks who were on probation for 20 or 30 years and nobody knew it. But there was no endpoint sometimes for when people were on probation. So this was put in a long time ago, 7 years ago. It was Justice Reinvestment 2. That when a person's on probation, there would be a midpoint review. So say the person was on probation for 6 years. At 3 years, there would be a midpoint review that would review how the person was doing on probation. If they were complying with all the requirements and all the conditions, that probation could be terminated, could be changed. If they weren't complying, the probation would continue, or if something else higher up could occur. That's how it plays out, correct? In a simple terms.
A little, yeah.
So I was a probation officer 2003 to 2009 or 10. Everybody was until further order of the court until S-156, where they said, we have this belief that probation is keeping everybody on supervision unnecessarily. And we had to respond to the whether the person was in violation, non-warrant status, or had things to do to, and the terms of probation were imposed before the midpoint. And then they were supposed to be still just like with until further order of the court. Did you complete your conditions? I submit for your discharge. Are you in violation? I read a warrant. Then the midpoint was imposed, which really in some way tied our hands to submitting these, whether we agreed or disagreed with the person being done with supervision. If statutorily they met these sort of oddly worded conditions, we're trying to assess like they met it. For example, up until 6 months ago, I supervised the sex offender team. And so we're submitting discharges saying they've met this. We're not saying we recommend they be discharged. We're only saying they met the statutory requirements. So term of probation, when it was originally imposed, my understanding was it was to keep corrections from keeping people on. But then they added another layer of the midpoint so that we have to halfway through assess and submit a report. But POs could use discretion, in my opinion, to say the person has completed their to-do list and has been crime-free and reporting as directed for a period of time. Here's a discharge. And that would
courts to make that decision.
we would submit saying they've done X, Y, Z like we used to do. I mean, your reference to JRI point, the first version, right? That it is, there's things that we could just go back to. That's my personal opinion. Sorry.
I think we can only submit midpoint if they have a term.
Yes, yes, sure.
So the further, until further order of the courts are still a problem if they're out there, but I don't think there's very many left.
No.
It's pretty much just like aggravated
offense.
sexual assaults.
Yeah,
And then part of the reason for that, by the way, is we can't recommend them for discharge because of Act 1, from 2009. So that's the only individuals we can't recommend for discharge.
the other, you can make a recommendation to the court, but it's the court that will then determine how that probation term is carried out.
Yeah, and it's very inconsistent, at least what we've seen as to the judge's response.
So it's more inconsistent on the court side than it is on DOC's side.
I think we're doing what we're statutorily required to do.
You're gonna get variation from court to court. I think part of the problem is that and this is, I'm kind of funneling some feedback we've gotten is that, victims assume that people are going to be on a certain term. The state's attorney probably sentenced them with an idea they'd be on for a certain term, or that was part of the plea deal. And then that kind of also arbitrarily gets disrupted. So like one of the problems that we've had with Midpoint is you have somebody who say they're not making a lot of progress in treatment, but we still have to submit them for Midpoint if they don't have a certain limit to that treatment. So like DVAP, it doesn't matter because you have to complete the 26 weeks. If you're on for a sex offense and you're 2 years in, you might not be ready yet, but we might have to still say they meet the statutory criteria. So we're kind of arbitrarily recommending a discharge when they really have.
So does the statute need to be tweeted instead of totally repealed?
On Midpoint,
The courts are using it as a term of probation, like you will be on for this amount of
Right.
time, instead of here's the term that you'll be on for no longer than, and DOC will submit a discharge some earlier point. The courts are seeing it as this is how long we told everybody, and this is a binding contract that you'll be on for this long. It's on the plea agreement, it's on the probation.
I'd also worry about term inflation, right? So if I'm a state's attorney, I want somebody on for 15 years. We had the same problem with other things that have meant to reduce. They can just ask for a longer term.
We had a guy on a 30-year term
Right,
of probation,
right.
chronic
Right.
burglar.
I mean, we've had state's attorneys tell us that they can do math, but.
It's a goal to get folks on probation if they're doing well,
Right.
Correct.
not being supervised.
Right. But it sounds like, to Maria's point, that was kind of like the Midpoint was kind of a solution to something that's already been sort of fixed because the until further the courts have mostly been resolved.
Yeah, it's
So-
a different.
You just have definitive terms.
We haven't figured it out. Okay, well, that kind of came out of left field for you folks, but it's out there.
That one was easier than the other.
Yeah, really.
Okay, thank you.
Thank you.
Thank you all back.
Thank you for what
We
you
will
do.
schedule more time on pretrial supervision, figure out. And we haven't had a chance to go through the new draft. I think we need time as a committee to kind of figure everything out. So thank you.
Thank you.
Thank you. Gotta go back to work.
She said she loved it.
You'll come back.
Thank you.
Thank you.
Have a great day. Thank you very much for your time.
So we're gonna shift gears. We got some folks here who are working in the recovery world. I have two folks who are recovery coaches who work with Turning Point. And we have Tracy from Rutland's. Tracy, I never can remember.
Yes, you can see.
I'm
I'd
coming
like to
up.
submit that it says I'm from Springfield Turning Point, but I am from the Bennington Turning Point, Dylan Johnson.
Wait, well, John is still Turning Point. You want to come on up
Yes,
or not?
thank you.
And then we have someone from the Bennington Turning Point, and where are the other folks here?
New executive director from here.
Bennington.
Yeah, so Carl and Joe are already gone for the day. This is normally the witness chair, but these are all.
So you can take all
You know.
Sit there, John, if you want. So we have half an hour because we have to be on the floor. Today's been a full day, so I will let you folks about what you do, because they're all recovery coaches that go into correctional facilities to help our folks enter into recovery.
Thank you.
Thank you. So if you could introduce yourselves for the record.
My name is Tracy Hauk, and I'm the director of the Turning Point Center of Rutland. I'm also a person in long-term recovery. Today is Recovery Day in Vermont, and I'm here to talk about the importance of our recovery coaching programming within the Department of Corrections. I also want to mention two important requests for the fiscal year 27 budget to help support local recovery organizations. First, we are asking the legislator to please renew the $800,000 we received in prevention funds in fiscal year 26. In order to level fund recovery centers and preserve current services in a time when recovery centers are facing increased demand. Also, please support the Vermont Department of Health's recommendation to appropriate $1.25 million in fiscal year 27 opioid abatement funds to continue the successful peer recovery coaching program within our correctional facilities in your budget memo to appropriations. I want to start by saying how much it matters to me, people like me, that you take the time to listen to voices from the community. Peer recovery work is deeply human, and I appreciate the chance to share what this funding truly means. I would like to ground this in real experience because peer recovery is ultimately about people, not programs. This is a story about one individual who received our services. Coachy Z, 38-year-old male. He has been receiving coaching at Turning Point of Rutland for a number of years, dating at least from 2016, with a serious problem with drug use. He was incarcerated for short periods, and while having a considerable amount of difficulty with his addiction, stayed in touch with us and reached out for help from us on many occasions. Although he had periods of staying in recovery and having productive employment, he had frequent relapses, but always came back to us at the end of each period. His perseverance with us and ours with him meant that he knew what he needed to do and retained a recovery focus, even when he was in a very bad place. His story demonstrates the importance of just staying in contact on his part and always being available on our part. As of this time, he has been entirely clean for 2 years, has a safe and secure place to live, has a very good job that can turn into a career for him, has a business plan for starting his own property management company for which he already has clients, and is close to achieving one of his main sobriety goals, which is regaining his driving privileges to open up further opportunities for himself. Where he once was so thin as to be in great danger of dying, I lost my place, hold on. From a number of causes, he is now a positive and healthy man with a good future in front of him. He is living proof that persistence in recovery really pays off, and that no matter how bumpy the road may be, one should never give up hope. And he didn't, and neither did we. What I just shared is not an exception. It is what peer recovery looks like every day across Vermont. Peers are people with lived experience who meet others without judgment and without an agenda. We build trust in moments when trust in systems is often broken, especially for people involved with the justice system. When someone is leaving incarceration or reporting to probation or parole, they are often scared, overwhelmed, and at high risk. A peer can be the difference between someone shutting down and someone leaning in. Peer recovery coaching works because we show up consistently. We walk alongside people as they navigate treatment, housing, employment, family reunification, and the emotional weight of starting over. We don't replace clinical care. We strengthen it by helping people stay engaged long enough for it to work. Peer recovery coaching began in 2016 at the Turning Point Center of Rutland, serving Marble Valley Regional Correctional Facility. In July of 2023, I was approached by the Department of Corrections to begin discussions on how to expand this program statewide. In July of 2024, grant funding was in place and recovery centers were beginning their programs in correctional facilities in their area. And by February 2025, funding was provided to work with all probation and parole offices. The funding request before you supports peer recovery coaching at 18 sites statewide, including 6 correctional facilities and 12 probation and parole locations through a partnership between Recovery Partners of Vermont and Department of Corrections. And another thing that I didn't add was that we are now part of the curriculum of the Vermont Corrections Academy. So every academy, we are there. This work creates continuity of care across systems. Instead of people being released with a phone number and a good luck, peers help ensure that someone has support before release and continues to have support once they are back in the community. That continuity saves lives, especially in the weeks immediately following release when overdose risk is highest. This is also about public safety. When people are supported in recovery, they are more likely to stabilize, less likely to return to incarceration, and more likely to become contributing members of their communities. The $1.25 million request is a responsible, carefully structured investment. Over $1 million goes directly to peer coaching staff, the people doing the work day in and day out. Operating costs are minimal, averaging about $1,000 per site and administration per year, and administrative costs are capped at 10%. This means the vast majority of funding goes straight to services, not overhead. From a fiscal perspective, peer recovery programs reduce costly emergency department visits, prevent relapse and overdose, and decrease recidivism. From a human perspective, they keep people alive long enough to heal and to rebuild. I am here today because someone believed I was worth investing in before I believed it myself. That is what peer recovery does. It holds hope until someone can carry it on their own. Vermont has been long been a leader in recovery-oriented systems of care. Supporting this 1.25 million increase allows us to continue that leadership and ensures that recovery support is available regardless of where someone lives or whether they are involved with the justice system. Federal dollars have funded this program in the past, but that funding ended. So the opioid abatement funds are needed to keep this program going to serve within correctional facilities and local probation and parole offices. And as of June 30th of this year, the grant that funds the peer support going into the correctional facilities will be ending. So if there's no more money, there could be no peers going into correction facilities. And probation and parole will end January 31st of 2027. So this is how critical this is. Please support the Vermont Department of Health's recommendation to appropriate 1.25 million in fiscal year 27 opioid abatement funds to continue the successful peer recovery coaching program within our correctional facilities. This is a joint request from Recovery Partners of Vermont and the Vermont Department of Corrections. It reflects Vermont values, compassion, dignity, accountability, and belief in people's capacity to change. Thank you for your time, your attention, and your commitment to the people of Vermont. I'm happy to answer any questions, and I also wanted to remind you there is a PowerPoint that was submitted and it's on the deck. A little more data.
Tracy, I got one question. When you started, you also talked about wanting to continue 800,000. And what is that for specifically?
That was money that was earmarked last year for the recovery centers. It doesn't go to all the recovery centers. Some centers got less funding, I believe. Is that?
No, that was something else. Excuse me.
I'm sorry, got my mind mixed up.
That's all right. We were awarded, the recovery centers were awarded $800,000 one-time funding last year, our prevention funds. And we're asking for that to be continued to level fund the centers to do the work they're currently doing.
Okay. So who had their hand up, Connor?
Yeah, thanks so much, Tracy. It's great to hear from you, and thank you for the work you do. It's good to hear from people who are on the ground in corrections, because like last week we heard testimony from a woman who was incarcerated down in Mississippi. Mm-hmm. She said she got high every day down in Mississippi. There was no problem getting drugs. I'm wondering, what do you see as far as our Vermont facilities? Is it conducive to recovery, or aside from the MOUD program, is someone more likely to recover in corrections, or maybe, if it's easy to get sort of illicit substances, there?
Well, I think there is the ability to get illicit substances in there. I'm not so much in the facilities anymore as I used to be, but I think, yes.
Thank you. My name is John Hoyt. I'm the program lead for recovery, coaching, and justice in Southern State Prison. And you had a very good question that no one has asked me to date. And my answer to you is, if you make a decision in the recovery community, in the prison, to stay sober, then that's what you'll do. If the drugs are available, doesn't matter where you are, right? It's no different on the street than anywhere else. If you're smart, you can figure something out, right? It's just, the addiction is unbelievable. Addiction makes people do things that most people wouldn't do, right? So, they'll compromise their morals and their values in order to get the drug of choice. So, and that's no different on the street. My answer to you, the most honest answer I can say, as someone who's been sober since 2002, is there's many opportunities in this life to make a bad choice. You have to decide whether you want to, how much your recovery means to you. So what we do, Tracy and I both, and all the turning points across the state, I'm not alone in this, is we build recovery capital. And that means your recovery is worth more than any bad decision would be, right? And we have many examples. Tracy gave a few really good examples. I have some data from our last quarter that shows how many connections we make at our turning point in Southern State with the men that work in our facility, work with our group. So I run a group basically Monday through Friday, recovery group out of a book called Houses of Healing. And it's a loosely based peer recovery program. And the book is written by men in prison and published in Massachusetts. It's a story of recovery, behavior change, understanding that peer recovery is super important in how to get to stay clean and sober. Am I making that clear?
No, I really appreciate that framing of it. It's, it's very helpful.
Thank you.
Thanks so much, sir.
You're welcome, sir.
But along the line, that question, is our system helping those who are incarcerated make the right decision? Or is it making it harder because there's so much availability within the system?
So I would say, if you don't mind,
Nope.
that's a two-part question. I think all turning points that are allowed to come into prisons across the state will increase the ability of the men and women who are in prison across the state to stay sober. I think all the support that we could possibly get from this grant, I mean, the grant money that you have provided so far, I'm not good with names, I'm sorry, where is it? The FY 27 opioid abatement fund, that money in particular is going to go a long way. It's $1.25 million. Am I correct in that number? It's going to go a long way in doing exactly what you're talking about. It's going to allow us to pay for the materials, the people, the community support that we need in order to maintain recovery for these men and women, because we have a women's facility. I work in the men's, but there are people who across the state that work in the women's facility as well. That money is specific. It's desperately needed. And I got to say thank you to start with for what you've done already. When I got sober, none of these programs existed, and it would have made a vast difference in my life. You change hearts and minds every day when you allow us to go into prison and break the thought change. Because you're talking about men and women across the state who are isolated from society and dwell on the fact that they've committed a crime until one of us coaches across the state can go in there and help them understand that they are not their crime. That was a day in their life that they can either choose to change now or let it run their life for the rest of their lives. And they are labeled as such because that's the way the system works. I'm not saying that's good or bad. That's just the way the system works. So when you're in recovery and you're dwelling on that and you're isolated from the community and you allow coaches like Tracy, myself, you, and anyone else in this room go in the facility and do this through this opioid fund money, we're changing hearts and minds. I mean, I can't tell you, that's just 1/4 of data. I could give you numbers off the top of my head, but I can tell you in our facility, in our catchment area, and Tracy probably has very similar numbers. I'm sure you guys do. We're numbers people. We have over 50% of the men that get out of prison and are introduced to recovery, whether it's at the police station or probation parole or at the prison. 50% of those people do not go back to prison. 50%. Now that number goes up and down. It could go way down next month. It could go up higher next month. But that just gives you an idea of the potential for what this could be across the state. This isn't like we're not siloed. This is just what we do in our turning point. We work with all turning points because the prison moves men across the state. So whatever programs we have, just by word of mouth, go across the state. So your opioid settlement money that you're hopefully able to give us makes a difference across the state. Each turning point collects its own data, but we all work together because the community moves. They're like gypsies in a way.
Yeah, I wasn't questioning the effectiveness turning point.
Yeah.
I was asking about the prison system itself, making it too easy to get the drugs if they make the wrong decision. That's what I'm asking.
Yeah, I was avoiding your question.
Because I personally think we need to change our perspective, and I'm wondering from the ground whether we're working from the wrong perspective.
So I will speak only for me. I will not speak for facilities. I will not speak for any of that because the program that we work with in Springfield Prison is amazing. They have made me part of the team there. We work actively with all aspects of the prison to have a very tight ship, quote unquote, with people, you know what I mean, to make it safe. Now, I don't dictate law. I'm not about to comment on how the DOC does their policies. I love the fact that they do what they do now. I'm 100% in support of it. Every program is boost. It's a staff issue more than anything else. Like you guys painfully know that we are running short on just staff in every prison across the state of Vermont. So if you want to work on that, that's great, but I'm not gonna put myself in hot water and answer questions that I'm not qualified to answer. I just, you know what I mean? I just can't do that. It's not a good thing to do, so.
And I don't think that we have the ability to know what DOC does to prevent that.
Correct.
You know, do I know that there is illicit drug use in there? Yes, there is, but I can't speak to what DOC's parameters are around that.
Okay.
I think it's more important that you said illicit drug use. Well,
Yeah, no, I just have a question on the data about Southern State. It says 441 people were reached over this last quarter, but there's not 441 people there. It's down in the 300s, right?
it's unique individuals of 59
Oh, so people that come in.
Mhm.
there
You
for a
gotta
short
read the
time, and
next one.
That's, well, I
Unique
saw unique
individuals.
individuals at 59, but I didn't know if that 441 was also unique individuals, but also just for general. Is that most of the people that were in Southern State over?
So that data is from Southern State.
Yeah.
That data specifically. Now, those people definitely go to Rutland. They definitely go to the other prisons across the state. But that data is drawn from our catchment in Southern State.
And we have a lot of people at Marble Valley that end up, once they get sentenced, probably go down to Southern State.
Yep, absolutely.
Other questions?
Thank you for what you do every day.
Yeah, thank you guys for allowing me.
Very helpful. Thank you.
Yeah,
Appreciate
it's
it.
great what they're doing. And,
I thought you were gonna testify more. If not, I do have a question. I just.
Oh, go ahead.
Get in the way.
I also.
Yeah.
I have a thing.
I'd rather hear you.
I'll say my piece very fast. I'll preface it by saying that I think I am here more as kind of a lived experience voice, being in recovery. I was here a year ago. I remember meeting some of you.
Remember you.
I will say I do believe part of what I wrote is ill-placed. I've made a few changes. I don't know if you guys have a copy of what I put on the file holder, but I will go. My name is Dylan Johnson. I'm a recovery coach at Turning Point Center of Bennington County. I also am the intake coordinator for the Paradise Certified Recovery House that is brand new for men in Bennington. I'm here today to connect my own personal story of recovery with the importance of recovery coaching in probation and parole and not in probation and parole, and everything else that the wonderful Turning Point Centers in Vermont do. I'm from Baltimore. I'm not from here. So to answer your question briefly, from my experience in talking to people here and having been incarcerated in Baltimore, the jails here are much better than Baltimore. Now, is that such a great comparison? I don't know, but I just wanted to put that out there. I had a great childhood, and in spite of that, I still ended up using cocaine for the first time in my late teens and heroin at age 21. Within a year, I had lost everything. My job, family, friends, house. I was living in California. I moved back to Baltimore to my father's house to try and get sober. Even with him supporting me, I quickly relapsed again and wound up homeless in West Baltimore. This was probably likely due to my father being in over his head. He's not a specialist. He tried his best, but it was not at the level of a treatment facility or anything like that. While on the street, I ended up getting into legal trouble. This led me to being put on probation in Baltimore in the summer of 2019, and I once again moved back in with my father. I was fortunate to have him, but I will say I was not very fortunate with the structure of the probation program that I was a part of in Baltimore. My PO there, and this is not to denigrate her, she was overworked, but she forgot my name every week when I came in there. And again, not to denigrate her, but not long after that, my father passed away. My mom, who lived up here, she came down to Baltimore and begged them to transfer my probation. It was transferred through ICOTS up to here in 2020, like not even a year into my probation. And soon after getting here, I realized really quick there were better ways of doing things. My probation officer was Michael Doheny, who's retired now, but in Bennington, and he was wonderful. He implored me, basically made me get in contact with the recovery community in Bennington, which started with the Turning Point Center. I ended up completing probation without incident. It was a 5-year probation. I he wanted to end it early. I heard you talking earlier with the previous group about ending it early, but because it was through ICOTS, Maryland didn't have an incentive, and it just never ended. So I did the 5 years. I went to CCV. I got a degree in behavioral science, and I had a work experience class that required me to get a job in the field. I went to Turning Point and I applied. They already knew me, and they hired me on the spot. Today, I'm a recovery coach in the center, the ED, and probation and parole. I am in charge of our data collection, and I do intakes for the Paradise certified recovery residents. I had some stuff on that, but I really want to talk about my work in probation and parole, since that is more aligned with the subject here. We run a group, a bi-weekly group in probation and parole for men and women. Me and a coworker of mine run the men's probation and parole group. That is the highlight of my week. It is my favorite thing I do. I really wish we could get into jails, but it's already covered by other great centers. And there's not a jail in Bennington really for us to go into unless it's the drunk tank. But the work in probation and parole has been incredible to see. I don't have some numbers on me, but we've been doing it for a year, and we have graduated the majority of individuals who did not get reincarcerated. And just seeing the change from when they first get told they have to go to the group and they're really unhappy about it, to by the time they graduate and get a $60 Walmart gift card and a little certificate, they are in great spirits. In fact, a lot of them just keep coming back. And so just that little bit there has been really eye-opening. And I just want to end by saying that many people here today are asking to support the 1.25 million for the recovery coaching program in corrections. And I cannot stress enough how much I support that as well, having been on the other end of this and seeing already the great work that you guys do here. Can always get better.
Thank you. Thank you.
Thank you.
Thanks a lot.
Anna?
Can I just say, I remember your story from last year. And I really appreciate, I imagine a lot of people and systems have failed you.
Yeah.
But you take ownership when you talk. And I imagine that really resonates with the people you work with. So
yeah, I mean,
I just want to say, I appreciate this so much.
Thank you. We talk about that a lot. There's a 50-50 thing here where, people always tell me, so-and-so person or system screwed me over. They were wrong. And a lot of times they're telling the truth. But part of this recovery is just saying, you know what? I made the initial decisions that led to this, right or wrong. And I'm going to accept them and, get myself out of the hole. And then I don't need to complain about it anymore.
Thanks very much.
But it says volumes that they continue to come back. So thank you.
Thank you.
You're welcome.
Yes, it's great. It's always good. Oops, Brian.
Well, just there is time now. I think I understand what was meant by recovery capital, but I was wondering if any of the three of you could talk more about, I believe that was the phrase that you used.
Yeah.
Yeah.
I mean, from my experience, it could be any kind of skills that you learned, getting connected with counselors, building a support network. It's all the different things that we use to kind of stay on the right path in recovery. That'd be my personal, not dictionary definition.
It's them regaining things back in their life, like employment, reunification with their family. If it's parenting with their kids, it's, and recovery capital is the whole process of recovery is regaining pieces of that as you go along. So it takes sometimes years. I mean, I have some of the stories that I submitted. These are people that have received coaching since 2016, 2017, and they're still getting coaching. So these are all things that develop over time. And giving them that positive feedback back when you're doing a recovery plan, they don't always see those as big successes. So it's like saying, yeah, but look at, you did this, right? And that is important. Or you didn't choose this behavior to react to this situation. They're not aware of the capital they're gaining. It's our role to give them that positive feedback so they feel invested in their life.
Yeah, it's amazing. A gentleman that's been working with us for about a year now went tubing with his daughter as a result of being able to rebuild that relationship through recovery. And he was all smiles. He's going to try to go again this weekend, but he's like over 50 and tubing is not always a great idea. So, but just to see exactly what both of you are talking about, but recovery capital is a lot, it's not always a tangible, like a bank account. It's a bank account metaphorically. Like there are things in my life that I have today that I never would have had without becoming sober. My mom passed away 6 months ago and, or no, my mother passed away.
I'll say it was your dad.
6 years ago. And,
Yeah.
I never would have gotten sober. I got to read my dad poetry as he passed away. Robert Frost is something he read to me when I was a child, and I got to do it with him. My mother worked for HCRS on the crisis team in the 70s, also worked in Woodstock jail. They used to call her the cookie lady. Unfortunately, I've run into some men in the prison that are still in the system that recognize me as Carol's son. So I got some street creds that way.
Yeah.
Well, and I think one of the most important thing ever since we've been doing this corrections program is I don't want the individual that is working on their recovery with the recovery coach. If they have a relapse, I don't want them to feel like they can't come back and say they had a relapse. They're, the biggest thing, if they'll sit there and say, oh, I can't look at you, I let you down. It's not about me. It's like, what's the important thing is, what are you going to do with it now? And you're sitting here right now talking to me. So you walk back in the door. That's huge. And they don't realize that. They think of it all as a failure. So you need to rephrase it in a way that it took you strength to walk through the door to admit you had a relapse.
Yes. And also, if I might, I don't know how much time you got, but I just wanted to say, probation and parole in Springfield has been amazing, along with the police department in Springfield has been incredible. So a lot of the guys we work with are on parole or probation. And they might have slipped, they might go back to use because they're just learning how to navigate life. And they'll come to us, your turning point, our turning point, you especially. The relationships that we build allow them to trust us and not be shame-based. And through that relationship, probation parole is not always interested in putting that person in jail, right? It depends on what happened and their attitude. A lot of times we can focus on a treatment-oriented program for them and keep them in society. And that's huge that we can work together with all these agencies because of the money that that 1.25 million opioid money is incredible. You guys are even thinking about having this conversation. And I just want to say thank you for everything you've done over the years. Like, it is amazing to have you guys as allies through this very difficult time in all of our lives, really. Thank you very, very much.
Second that.
Yeah.
I said, I second that, coming from different situations. Also, shout out our probation and parole, Gina Kondo, who's been incredible in incorporating recovery programming into it and not just immediately sending somebody back to jail.
Aside from this, I work in the treatment court as well. That's another subject for another day. But thank you all very, very, very much for what you do today. I know you have a busy schedule, and just it means a lot to me personally that you take the time out of your day to do this. So thank you very much. I really
Thank you for coming. That's more.
It gets me out of the house. My wife.
Truth comes out.
His wife is the director.
Yeah.
I'm the board, so I get that.
Yeah. I wasn't blushing before, I am now.
So I want to thank all three of you for coming up. I think it's really important for legislators to hear from folks who are really working hard on the community, working hard on the ground, really taking care of other folks in our state. I really want to thank all three of you for doing what you're doing.
Thank you.
Okay, folks, another day in the books.
That was a long one.
It's Wednesday.
It's like Friday, but it was Thursday.
Seems like it just got here yesterday. So.
I figured.
Let them leave. So, YouTube, we're back on here tomorrow. And we're gonna be starting with DOC's budget for 2 hours, so.
Do you want me to do a print out of the questions again?
Yes, please do. So we'll be back tomorrow morning at 8:30 on YouTube, so we are, I don't know how much is on the floor.
I don't think there's that.
That's saying just an hour, but it didn't look like much.
If we get out by 4, it'd be great to come back in here and just kind of have a committee discussion to kind of figure out where we're going on.
A couple.
What is trial and what was the other one?
Costs of the weather conditions.
Why is it supposed to start snowing again?
It has
has
been
been all day.
snowing all afternoon.
It's been snowing all day.
It just stopped. Well, no, it's still.
I'm just saying for those traveling.
Word.
Trying to think, what else do we have today? I had so much today that it was.
I know Mary wants to talk about the,
What I had, no, the parole board and the pretrial. If we had time today after the fort, just kind of come back and see if we can spend 15 minutes maybe talking, trying to